हेलो वंस अगैन आई एम डॉक्टर शीतल शर्मा और आज का टॉपिक ऑफ डिस्कशन है द इस्टेब्लिशमेंट ऑफ ऑल इंडिया जुडिशियल सर्विसेज। क्या आप जानते हैं दैट बिफोर द ट्रांसफर ऑफ पावर द सेक्रेटरी ऑफ स्टेट फॉर इंडिया ही वांटेड टू वाइंड अप इंडियन सिविल सर्विसेज एंड उसी टाइम पे इन द ईयर 1946 सरदार पटेल ही कन्वीन्ड अ मीटिंग ऑफ premiers of 11 provinces in order to discuss that what is going to be the future of Indian civil services and police services, and they all agreed to retain the Indian civil services. Before independence, the position of subordinate judiciary was manned by the members of Indian civil services, and then they used to mark up their way to the district courts, to the high courts, or to the Supreme Court. Even the 10th Chief Justice of India, Justice Kailas Nath Vanshu, he was a member of Indian civil services. Before independence and after independence, there was a feeling in the Indian political establishment that states they should be evolving their own mechanism for civil and criminal justice administration, and a separation of judicial, executive and revenue courts has always been the long-standing demand of Congress party ever since its first session in the year 1885. Even Article 50 of the Constitution, directs the state to adopt measures in order to separate the executive and judiciary from the public in the public services of the state. But it is interesting to note here that in the year 1958, Law Commission actually recommended the establishment of All India Judicial Services. This matter was taken up in the Chief Justices conferences in the year 1961, but again, the matter had to be shelved. Why? Because there was a strong criticism and there was opposition from the Chief Justices of the High Courts and state governments. Law Commission once again in its 77th report and 116th report recommended for the creation of All India Judicial Services. But again, the matter had to be shelved. Once again, the Justice Shetty Commission, it discussed the creation and it also suggested the creation of All India Judicial Services. And Justice Shetty Commission, as we know that this is also known as the first National Judicial Pay Commission. In the year 2012, the Government of India proposed the idea once again for the constitution of All India Judicial Services. But again, the matter had to be shelved out because there was no consensus among the Chief Justices of the High Courts and state governments. There is a provision in Article 312 of the Constitution for the establishment of All India Judicial Services. No doubt we have this provision, but the resolution has to be passed before the Rajya Sabha, for which we need 2/3 majority of the members present and voting. And then the parliament is supposed to enact the law on that. So that means, there's still not, a lot of work that needs to be done. And it is interesting to note here that there is a report which came out in the year 2012. This was the report of the National Judicial Courts Management Systems, which said that in the next 30 years there's going to be a huge number of cases which are going to be filed in the courts. Approximately that can be above 15 crores, and for the disposal of these cases we need more than 75,000 judges. Some are in support of the establishment of All India Judicial Services on lines with the other All India services in order to strengthen the justice delivery system in India. But one thing that we have to see here is that basically today the current situation is that filling up of judicial vacancies has always been the domain of the high courts and the respective state governments. So basically, the government needs a comprehensive policy in order to include various stakeholders, because there are many stakeholders involved, so that means they are going to hold different opinions. So the government obviously have to adopt a consultative process. In the year 2012, in the meeting of Secretaries of State, the idea and the proposal was made for the establishment of All India Judicial Services. This proposal was again discussed in the year 2013 in the Chief Justices Conference, and few changes were also presented. Looking at the changes made in the Chief Justice's Conference in the year 2013, again the proposal was discussed in the Chief Justice Conference again in the year, which held in the year 2015, in order to see, whether there is a chance of establishing All India Judicial Service or not. But after repeated attempts, there was no way out. And finally, in the year 2019, the government of India actually initiated a consultative process for the establishment of All India Judicial Services. And it is also interesting to note here that in the year 2002, the Honorable Supreme Court actually, gave the directions to the central government for the establishment of All India Judicial Services. And directions were also given for, improving the working conditions of the subordinate judiciary. This was done in the case laws of this is All India Judges Association versus Union of India and others. So time and again the government of India has pressed, even the Law Commission has pressed for the establishment of All India Judicial Services. But till date, the matter has not come up to any kind of a conclusion. Why? Because there has no consensus between the Chief Justices of the High Courts and the state governments. And the current situation is that finally in July 2022, Union Minister for Law and Justice, Mr. Kiran Rijiju, has said in the Rajya Sabha that there is presently actually no proposal for the settlement of All India Judicial Services because of lack of consensus between Chief Justices of the High Courts and the state governments. So, आपको क्या लगता है? क्या हमें एक ऑल इंडिया जुडिशियल सर्विसेज सेटअप करनी चाहिए ऑन द सेम लाइंस एज अदर ऑल इंडिया सर्विसेज इन ऑर्डर टू स्ट्रेंथन द जस्टिस डिलीवरी सिस्टम इन इंडिया और नॉट? आप अपने ओपिनियंस को कमेंट सेक्शन के अंदर डाल सकते हैं. थैंक यू सो मच.